One ground that is not valid is, well, I just don't like the judge and I don't like what happened. There has to be something substantive. Either the judge committed an error of fact or the judge committed an error of law. So if the judge failed to take into consideration some facts that were presented, or the judge got the facts garbled and misinterpreted them, that can be a ground for appeal. Or if the judge misstated the law and misinterpreted the law, that can be another ground for appeal. But just because you don't think that's fair, because that judge should have ruled in my favor because I'm a nice guy, well, you're not getting anywhere on that one. And sometimes I have people contact me with requests to do an appeal that are really just frivolous. For example, I had someone contact me who wanted to do an appeal of a dismissal of a Chapter 13 bankruptcy case. The case was dismissed because the debtor, who represented himself, a pro se debtor, had not filed all the documents required within the time specified in the rules and had not attended the meeting of creditors under Section 341A. In other words, all the debtor did was file, in essence, a face sheet filing and took no action to prosecute the case. So the bankruptcy judge dismissed the case for failure to prosecute. Debtor now wants me to appeal, and I'm not going to do it for the obvious reason that this is frivolous. There is no error of fact. There is no error of law. This is just, well, gee, I want to have more time. Not going to work. So you really do have to have some substantive claim that you can point to say, the judge made a mistake. And if you've got something like that, you can go ahead and appeal. I will say the appellate track record is not all that great. I have read in various places that appellate success in federal courts is something on the order of 10%. So if you're appealing in the federal system, you better have a very, very good argument, because if you don't, you're just spending more money on really nothing more than a quixotic venture. But if you do have a good argument that the judge made an error of fact or made an error of law, or the judge abused his or her discretion in coming up with a decision, then you can give that a try.